So, as mentioned in my last two Maddie Soto videos, this week the prosecution have put out multiple responses to a number of the motions that were filed by Stearns' defence team. All up, I think the state has probably put out maybe 30 responses this week, which is only responding to about half of the motions that have been, less than half of the motions that have been put out by Stearns' team. As you know, they went a little bit crazy. They put out something like 70 plus motions. Complete waste of time, given that half of them aren't even based in precedent. There's no law behind them. They're just little fantasies that Stefan's team have come up with. So far from reading through the responses that I've looked at, it seems to me that Will J has a little bit of a sense of humour and is very subtly taking a jab at the defence team. All three of the documents that I'm going to look at today come directly from the master himself, Will J, and they are directed to the defence's attempt, in my opinion, to control who is brought forward as witnesses and to control how the prosecution run the trial with regards to witnesses. Essentially, these motions appear to be attempting to remove any power from the prosecution with regards to witnesses. And of course, you know that when it comes to a trial, witnesses are, of course, the most important thing. Now, with these documents, I am going to tackle them raw. Essentially, I haven't read... I've ran my eyes over them, but I haven't actually read through them at this point in time. So I'm seeing them in real time, pretty much. One thing I do want to note, however, is what I've seen from the responses that have been put out from Will J previously, is that it's almost like he likes to lull the defence into a false sense of security. Because there's a few times when he started saying something that sounded like he was almost siding with the defence. And then he's basically flipped it on its lid and shown why it just doesn't stand. So he does do that again, from what I've seen in these motions or in these responses. From glancing over the first document, it appears that there is I guess you could say, common sense response that Will J gives to part of one of the motions, and that's one of the few times when you actually see him agreeing with the defence team. But at the same time, it's such a basic thing that you look at it and think, why did they even file a motion regarding that in the first place? Now, for anyone who wants copies of these documents, if you're wanting to get hold of them without having to go chase them up, they will be available on my Patreon. If you are not aware, my Patreon is free for anybody to join. All you need is an email address, and then you can join up. It costs you nothing. Once you have become a member of my Patreon, then basically any of these documents that I've gone through will be available there on my Patreon and are free for you to download. With that said, let's take a look at these responses that have been filed by Will J. Okay, so this one is State's response to defendant's motion for disclosure of Brady versus Maryland materials of specific officers on list of law enforcement officers whose credibility is questioned by the 9th Circuit State Attorney's Office. Try saying that really fast. So basically, This is a response to the defence wanting the state to do their homework for them. Okay, I'll just shorten that first bit. Through the undersigned Assistant State Attorney, states as alleges and follows. The State Attorney's Office discloses to Defence Counsel any officer on the Brady list. As the defendant states in his motion, Florida Rule of Criminal Procedure requires the state to disclose the existence of exculpatory evidence. However, I love these howevers from Will J. However, telling the defendant this information exists is different than retrieving it for him. Before the state can be ordered to gather this evidence for the defendant and provide it to him, the defendant needs to exercise due diligence to gather this evidence first. If he is unsuccessful, only then can the court order the state to gather this disclosed information for the defendant. So essentially what he's saying here is that the defendant needs to do their own research, and if they identify that one of the witnesses is on the Brady list, then they can request that information from the state at that point in time. They can't ask the state to do their homework for them and tell them if any of their witnesses actually are on the Brady list. So there's a huge difference there. Basically, they want the state to do their homework for them. In Medina v. State, the Florida Supreme Court noted that the defence has the initial burden of trying to discover such evidence and that the state is not required to prepare the defence's case. Not their job to do your homework, Lizzie. Holding that the state has no duty to obtain information for the defence that the defence is able to obtain by means other than production by the state. In other words, it's publicly available, so it's not up to the state to have to provide the information. It's up to the defence team to do their job, do their research, and identify it on their own. And then you have him adding another precedent, because I think he's recognised that apparently that's the language that Lizzie speaks. Pull out every precedent you can find. This is Lizzie, of course, regardless of whether or not it actually fits. Will, on the other hand, is throwing back solid precedents. So this one, Yanetta v. State, noting that a defendant should not be permitted to employ the pretrial discovery procedures for disclosure of information or documents which by the exercise of due diligence are readily available to him by subpoena or deposition. Meaning, again, if he can find it out for himself because it is readily available, then it is basically an abuse of the whole discovery process to be asking the state to do their homework for them. Paragraph 5. The Florida Supreme Court has maintained this position. Young v. State. In Florida, defendants have the right to pretrial discovery under our rules of criminal procedure, and thus there is an obligation upon the defendant to exercise due diligence pre-trial to obtain information. Again, due diligence. Do your own bloody homework. Therefore, the defendant's motion should be denied without prejudice. If he cannot obtain this disclosed information himself, he should then request the state to obtain it. If a dispute arises, then he can petition the court for relief. So essentially what is being said here is that it is up to the defendant to identify anyone who is potentially on the Brady list, and then they can make a specific request for that information. But other than that, it's basically asking the state to do their homework for them, to do their work for them. And, maybe if they weren't sitting there coming up with ridiculous motions to file in court, they would actually have time to do their due diligence where it actually counts. Okay, so this one is the state's response to defendant's motion in limine on trial procedures. Now, this addresses a few different things, and the first one, as you will see, he's basically in agreement because it is just basically standard practice. So, yada yada, all that comes now stuff. The state agrees that it is improper for the court to deem a witness an expert. Each party should lay the predicate for their experts' opinions and then ask the experts for those opinions. If the opposing party does not believe the predicate for the opinion has been laid, they can raise an objection. So that basically means that they have to establish the credentials of the witness in court. They can't just bring someone in and go, "This is Joe Blow, he's an expert on DNA testing." They would have to establish how long he's been in his position, any other positions he's held, what is his experience, all that sort of thing first, to show the court, of course, mainly to show the jurors, that his opinion is worth listening to. At that point, the defence can raise objections if they don't think that basically the state has shown this person to be expert enough to share their opinion on whatever it is. So, if the state were to produce a regular police officer who had done a half day's training on DNA testing and claimed they were an expert, then the defence could turn around and say, we object, this person really has absolutely no credibility whatsoever. That sort of thing. Now, paragraph 2 is essentially addressing Stearns not wanting the jury to know that he was indicted by a grand jury, essentially. And the response here is because it is the court's discretion to allow the indictment to go back to the jury with the standard caution that it is merely an allegation and not evidence of guilt. It is therefore not improper for the court to mention grand jury to the jury panel. The indictment has a signature line for the foreperson. So basically, Stearns didn't want the jury to be aware of the indictment, which is, kind of ridiculous because I think they figure it out anyway. And yeah, essentially, so long as the jury are aware that a grand jury indictment means that it is an allegation and not an evidence of guilt, then it should have no impact on their final decision. So another one, Will J has very effectively knocked that one down. Okay. The defendant's request for the state to only list witnesses it intends to call should not be granted. Requiring the state to disclose which witnesses it intends to call at trial violates the work product doctrine, State v. Williams. Additionally, as things develop during trial, particularly homicide trials with dozens of witnesses, a witness the state originally did not intend to call may end up being called as a witness And if one or more of the jurors knows the witness, this could result in jurors potentially being removed from the middle of the trial. This is an outcome nobody wants. So that one's kind of two-pronged. He's saying, for starters, basically it would be like if they gave a list of only the witnesses that they intended to call, for starters, it would be like giving someone a list of exam questions. These are the questions that are going to be given in the exam. This is all you need to study. Basically, the defence needs to get off their ass and actually do the work and be prepared for any of the witnesses that have been listed in disclosure. The other prong to this, which has been pointed out, is if they were to say, this is the list of witnesses we are going to use, and then during the proceedings they decide that there's another witness that they need who was on their original list, if they bring in that witness, which they hadn't originally said they were going to bring in, then you could end up with issues with the jury because the jurors wouldn't have been pre-warned of that witness. Meaning that if they decide to bring in Joe Blow again, they weren't going to use Joe Blow, but they decided they'd use him anyway because of basically the way the questioning had gone. They felt they needed an additional witness to cover something because they didn't think that they covered it as well. So they decided, after all, that they are going to call Joe Blow. But he wasn't on that original list of the ones that they were going to call from the entire witness list. And suddenly, two jurors, Bob and Betty, realise they know Joe Blow. And suddenly they can't be on the jury anymore. Because there was no pre-warning that Joe Blow was going to come in. And suddenly, halfway through the trial, you've lost two jurors. I know that's a really poor example, but, basically his point is, the whole point of disclosing all witnesses, regardless of whether or not they are going to testify, is, first of all, it is a fluid thing. Any case is a fluid thing, so it's going to change. So there is a possibility if they say that a witness is not coming in and then they need that witness, that could mess up the trial. But the other side of it is that basically it's pure laziness on behalf of the defence to want to know exactly which witnesses are being used so that they only have to prepare for them. So paragraph 4. Therefore, the court should grant the defendant's request regarding expert witnesses and deny the defendant's requests regarding the term grand jury and the reading of all potential witnesses. I think I actually prefer these responses that are more kind of common sense responses than ones that are full of precedents, because they're so much easier to read. Now, I found this one kind of interesting because it gave me a glimpse of pre-trial proceedings in an area that I wasn't overly familiar with. So this is State's response to defence's motion to enjoin the prosecution from using witness statements or testimony from other witnesses in preparing witnesses to testify or give statements and from preparing witnesses together. So basically, they're saying they don't want the state to produce anything other than statements previously made by each individual witness to help prepare those witnesses for trial. So they don't want them sharing things that have been said by anybody else, and they don't want them preparing witnesses together, meaning that if you have two witnesses who are going to be making similar testimonies, they don't want them together. I guess that would apply to your law enforcement. So, for example, if they were preparing Detective Tagler and Detective Acosta, then they may want to prepare them together because they did the same interviews. This is me just guessing, but I think that's where this is coming from. Okay, let's see what Will J has to say about this. The defendant requests this court to allow him to invoke the rule of sequestration at this point in the proceedings and to prevent the state from, if needed, refreshing a witness's recollection with items not generated by that specific witness. The defendant provides no authority to support his request, and the authority in place requires this court to deny defendant's motion. So again, we have Will J pointing out that the defence team are a bunch of twits. In making this request for the rule of sequestration to be applied forthwith, the defence has overlooked Florida Statute 90.6161, which clearly defines when the rule may be invoked. The statute states, at the request of a party, the court shall order, or upon its own motion, the court may order, witnesses excluded from a proceeding so that they cannot hear the testimony of other witnesses except as provided in subsection 2. Which of course is pretty much standard protocol everywhere. This is why quite often in cases you have family members' testimony early on in the case, because then they can actually sit in and watch the rest of procedures. Sometimes there will be exemptions granted for family members so that they can actually sit through the proceedings, because, you know, this is when it's not going to affect their testimony, essentially. It is well established that the rule applies to trials and other proceedings in which witnesses may be called to give testimony in court. In Lambert v. State, the 5th District Court of Appeal stated it is within the discretion of the trial judge to invoke the rule of sequestration after opening statements. Relying on cases interpreting the corresponding federal rule of procedure, the court in Smith v. Southern Baptist Hospital of Florida, prior to the enactment of the Florida statute, held that the rule of sequestration did not apply to discovery depositions. It is clear from the wording of the Florida statute that the rule of sequestration does not apply to pre-trial meetings between an attorney and a witness. Accordingly, the defendant's request is premature until trial or other hearing during which a witness will be called to give testimony. Meaning, essentially, yes, when we actually get to trial, then you can make the request for sequestration of witnesses from trial proceedings until after they have testified, but you can't tell the state how to run the preparation for trial. The defendant also asks the court to enter an order preventing the state from using any document not generated by the witness to refresh that witness's recollection, and the request appears to focus on pre-trial preparation rather than trial. The defendant again fails to cite any authority in support of his position, and again, this request is contrary to the long-standing legal precedent. So you see in trials quite often where a witness is given a copy of their earlier testimonies to run their eyes over, to say, okay, yeah, that's what I said. And obviously, you're not going to hand them over someone else's testimony and say, does yours agree with theirs? That's just not allowed. But that's not what they are asking here. So now you have Wilcox versus State. The Florida Supreme Court explained, we conclude that the trial court erred when it prevented Wilcox from attempting to refresh, Ritchie's recollection with either the summary of Jean's statement contained in the arrest affidavit or Jean's actual statement. When a witness testifies that he or she has no present recollection or memory of a fact, a party may show the witness a writing or other object to attempt to refresh the witness's recollection. When a writing is used only to retrieve present recollection of a fact, it is not required that the writing be written by the witness. In fact, if the witness's memory is jogged and the subsequent testimony is based upon an independent present recollection of the fact, that which prompted the witness's memory is immaterial. Bank versus Bigelow, it is immaterial what constitutes to spur the memory, as the testimony, when given, rests solely upon the independent recollection of the witness. Furthermore, writings or objects used to refresh the memory of a witness need not be admissible evidence. So basically, when they're preparing their witnesses, they don't have to actually then share those documents as admissible evidence in court. So something that the defence may basically put a motion for as being inadmissible in court is not something that is then excluded from being used for preparing a witness, basically. And this then pretty much says what I just said. As the corollary to the rules allowing such wide latitude in the choice of writings as mnemonic aids, the writings used to prompt recollection are not necessarily admissible in evidence themselves. Here, the trial court prohibited Wilcox from refreshing Ritchie's recollection with Jean's statement because this is not a statement directly attributed to this witness that can refresh her recollection as to what she knew and what was said, meaning the statement that they wanted to show the witness basically wasn't something that she had knowledge of. So it wouldn't be her testimony. It would be like if you went to the movies tomorrow and you saw something happen and you had to write a report, and then someone else didn't see anything, and an officer went, read this report and then you can actually tell us what happened also. So it's got to be in relation to shared knowledge, shared experiences. Okay, so where was I? This is based on somebody else's police reports and arrest affidavits are not admissible evidence. You can use it to refresh the recollection of officers who wrote it to determine whether or not there were other matters they have missed. This witness cannot be refreshed or impeached based on a statement that she did not make. I'll come back to that. Thus, the trial court prohibited Wilcox from attempting to refresh Rich Schuander's recollection solely because the evidence was the statement of another individual and was not itself admissible evidence. This was error. All right, cool. Sorry, I thought, hang on, isn't this the whole argument? So basically, this person was not allowed to see police reports and arrest affidavits from others, which would have refreshed their memory, and that was deemed by the court as being an error because basically it was pre-trial. Sorry, I feel like I'm not really explaining this overly well this time round. Okay, let's do it this way. So let's go back to Acosta and Tagler. So let's say they're doing their preparation for trial and they're asking Acosta questions relating to the interview that they did with Stearns where they took his phone. And maybe there's something that Acosta does not remember and is not in his actual written report. There is nothing to then prevent them from saying, can you have a look at Detective Tagler's report and see if that jogs your memory? Is there anything that you have forgotten to mention? Or likewise, preparing for trial, they may choose to have both of them at the same time to do the preparation and talk through whatever the relevant thing is with the pair of them present. There is no prohibition to either party using anything to refresh a witness's recollection, either pre-trial or during trial. So there you go. I thought they could only give their own witness statements, but turns out they can use anything during trial. Therefore, defendant's statement that sharing of memos and reports among witnesses not only violates evidentiary rules against the admission of hearsay, but further violates the defendant's constitutional right to confront his accuser and test the evidence against him through cross-examination. It is contrary to well-established precedent and simply incorrect. So it seems that once again, the defence team have tried to make up the rules as they go along, and Will J has quite efficiently gone, yeah, nah, there's no precedent for this, and actually there is well-established precedent for the opposite of what you are claiming. What you are claiming is wrong. So down the bottom here we have, wherefore the state requests this court deny defendant's motion to enjoin the prosecution from using witness statements or testimony from other witnesses in preparing witnesses to testify or give statements and from preparing witnesses put together. So stick that in your pipe and smoke it. So again, Will J has quite efficiently knocked over several motions that were put forward by the state, by the defence, that just had no real solid weight behind them. I mean, honestly, if they are going to prepare properly for this trial, they would do better rather than coming up with all these ridiculous motions that have no legal basis and that are based on pure fantasy or that are based on a complete misunderstanding of statute. Maybe instead they should spend their time on actual trial preparation. So, in my mind, I've been focusing on 15th of July, which is the start of the actual trial, and thinking, okay, well, that's when things are going to start getting interesting. But I realise now that the pre-trial could actually be pretty damn interesting also. So that's the 2nd, I believe, of July, so that's coming up really, really soon. And I think, based on what we've seen in these motions and based on the responses, I actually think that the pre-trial proceedings could actually be quite interesting, quite entertaining. And I'm really looking forward to seeing Will J and Monique Worrell just completely walk all over these fools. Now, I must admit, I find myself wishing that I had a decent laptop so I could actually live stream the trial or the pre-trial, well, both the pre-trial and the trial, because I think I would have a bit of snark going on there. Although, that said, doing recaps gives me a better opportunity to snark it up. And you know how distracted I get on live streams, so it's probably better this way anyway. And of course, as you will probably be aware, most of the proceedings are going to be happening when I'm fast asleep, hopefully in La La Land. And so it's probably better if I try and make myself watch afterwards when I get up of a morning. Now, there's still a few things that I want to address in terms of responses from the state. So I do aim to have another one of these videos out tomorrow, looking either at one of two topics relating to the jury, in terms of jury instruction and jury selection, or looking at the many attempts by the defence to have the DP thrown out. I do also have a number of projects going on in the background here, but I'll bring you up to speed on them when they are just a little bit closer to completion. So that brings us to the end of this video. Hopefully this one, unlike the one before it, won't be sitting there for 24 hours before I can publish it. I find it especially frustrating with relation to the Claire Bell case, because this was something, or that one was something I was going to address last night, but I was tired, so I left it till this morning, so I'd already lost 12 hours doing it. And if I lose another 12, 24 hours, given the fluidity of the case, I've probably sat and made a video for no purpose whatsoever, as things may change. Honestly, there are some days when it feels like YouTube is just putting enormous obstacles in the way of YouTube creators. So anyway, let's forget about that. This brings us to the end of this video. So thank you for watching. If you are new to my channel, please subscribe. Also, please hit the like button and please leave a comment below. Thank you, and I will catch you in the next one.